He hauls bolts of wool.
London,
He sweats through the
1289.
sun. He sleeps on the floor, and at the end of
A
the
man
week,
walks
he does
into a
not collect
workshop
his
on
wages.
Cheapside,
London,
the beating
1289.
commercial heart of
A
the
man
city.
walks into a workshop
He
on
hauls
Cheapside,
bolts of wool.
the beating commercial
He
heart of
sweats
the
through
city.
the summer. He eats in the corner, sleeps on the floor, and at the end of the week, he does not collect his wages. His wages go to someone else entirely. Not a crime boss, not a moneylender, an alderman, a city councilman, a man who sat in Guildhall and helped write the very laws that governed London. And here is the part that will keep you up at night. This was all recorded, openly, in the official books of the city, because it was not, technically, illegal. To understand what was happening in late 13th century London, you need to hold two contradictory ideas in your head at the same time. Idea 1. England had formally abolished slavery in 1102. At the Council of Westminster, the Church declared the buying and selling of human beings a sin. No more slave markets, no more chattel. England congratulated itself on being civilised. Idea 2. Feudal serfdom, what the law called villenage, was alive, thriving, and deeply embedded in English society all the way to the 15th century. The difference between a slave and a serf, legally speaking, was precise and brutal in its precision. A slave was property with no legal personality whatsoever, no right to own, sue, marry, or exist in court. A villain, or nativus, from the Latin word for born, was a person bound to the land. They had legal personality in some courts. They could own tools. They could be fined. They could, theoretically, testify. But they could not leave their lord's land without permission. Their labour belonged to their lord. Their children inherited their status. And if a lord wanted to extract money from their labour, he could rent them out, like equipment. The 1102 abolition of slavery hadn't ended exploitation. It had rebranded it.
The evidence.
The evidence.
The letterbooks of Guildhall.
The letterbooks of Guildhall.
Here is where history gets
uncomfortably specific. The Guildhall letterbooks are among the most meticulously preserved civic records in medieval Europe. They contain contracts, disputes, complaints, property records, the administrative DNA of medieval London. And embedded within them, largely unremarked upon for centuries, are 17 cases, 17 documented instances spanning roughly 1270 to 1310, of Nativi, bound serfs, being rented by their lords to urban merchants and craftsmen in London. The structure of these arrangements was consistent. The lord delivers the worker to the merchant. The merchant benefits from the labour. At the end of the agreed period, weeks, months, sometimes a full year, the payment goes not to the worker but back to the lord. The workers are named. Their lords are named. The merchants are named. The sums are recorded. One of the landlords, one of the men collecting rent on another human being's labour, held a seat on the London City Council. An alderman, a man of governance, a man of law. His name appears in the letterbooks, not in a section about crimes or complaints. It appears in routine commercial records, because this was routine. The legal grey zone. Now, someone watching this might ask, how? How was this happening inside London, of all places? Because London had a rule. A famous rule, repeated in civic documents with genuine pride. City air makes you free. Stadtluft macht frei in German. The idea that if a serf escaped to a city and lived there for a year and a day, they became legally free. Urban residence was supposed to dissolve the bonds of feudal servitude. This was real. It was enforced in some cases. Runaway serfs did find refuge in cities, but it had conditions. The serf had to have escaped, fled, without the lord's pursuit. If the lord came and claimed them within the year, the city would often hand them back. And critically, if the Lord voluntarily brought the serf to the city as part of a labour arrangement, the freedom clause did not apply. The serf had not fled, they had been delivered. So the lords had, essentially, found the loophole in their own law. Bring the serf to London yourself. Rent them to a wool merchant or a dyer or a leather worker. Collect the payment. The serf never has the chance to claim residency because they never arrived freely. They arrived as inventory. Medieval legal scholars were aware of this tension. Some argued that even a lord-delivered serf, once residing in the city, could claim freedom after a year. Others disagreed vigorously. The courts ruled inconsistently, which is exactly how grey zones work, not through ignorance, through deliberate, profitable ambiguity. Who were the Nativi? Let's talk about the people at the centre of this. The 17 individuals recorded in the letter books are listed mostly by first name and their lord's estate. They have no voice in the documents. They appear as subjects of transactions, not as parties to them. What we can reconstruct cautiously is their situation. Most were rural workers, from manors in Essex, Hertfordshire, Middlesex, the counties surrounding London. Their lords were minor landowners and gentry, the kind of men who didn't have the capital to expand their holdings, but could extract value from their serfs in new urban ways. The workers were rented to merchants dealing in cloth, leather, foodstuffs. Physical trades that needed reliable, unprotesting labour at a fixed cost. For the merchant, it was efficient. No negotiating wages. No risk of the worker leaving. Complain to whom? The Lord owned your labour contract. For the Lord, it was increasingly necessary. The late 13th century was a period of economic pressure on the English gentry. Wool prices fluctuated. War taxes drained estates. Renting human beings to London merchants was, for some lords, a meaningful income stream. For the workers, we don't know exactly what they experienced. We can guess. Displacement from their communities. Labour in unfamiliar trades. No legal avenue for complaint within the arrangement. We know they worked. We know they did not keep what they earned. We know at least some of them were paying attention to the city around them. The secret fact. And here is where the story becomes something else entirely. While reviewing documents adjacent to the letter books, tax rolls, ward lists, contribution records from the same period, researchers have found something that the medieval legal system apparently could not reconcile. At least 2 of the individuals named in the nativus rental records, 2 of the 17 workers listed as bound serfs, rented as labour, appear in other civic documents as taxpayers, contributing to local ward levies, listed among the residents of their district as free persons liable for civic taxation. Let that land, the same man, the same name, the same period, the same city. In one document, property of his lord, rented out for commercial labour. In another document, a free resident of London, assessed for taxes, implicitly recognised as a citizen. The city's tax collectors saw a free man. The city's commercial records saw a serf. He was, simultaneously, both. This is not a clerical error. Or rather, it might be, technically, a clerical error in one of the documents. But the fact that it could happen, that the systems were disconnected enough that this dual existence was possible, tells us something devastating about what freedom meant in a medieval city. Freedom was not a status. It was a context. You were free when the tax collector came. You were unfree when your lord came. And the city, the institution that built its identity on being the great liberator of the bound, was collecting both the tax and the rental fee, sometimes from the same individual, without the left hand acknowledging what the right hand knew. What this reveals about medieval freedom. Historians of medieval urbanism have long pointed to the city as a progressive force. The place where guild membership, civic identity, and commercial participation created something approaching equality under law. And that story is not entirely wrong. Cities did offer more mobility. Cities did challenge rigid rural hierarchies. The city air principle did free real people. But the story of these 17 cases, and especially those 2 taxpayer serfs, reveals the limits of that liberation with terrible clarity. Medieval urban freedom was not a wall that kept exploitation out. It was a negotiation, a set of competing jurisdictions. Ecclesiastical courts, royal courts, manorial courts, and civic courts all claimed overlapping authority over the same bodies. And in the gaps between those authorities, exploitation found its address. The alderman who rented workers understood this perfectly. He was not circumventing the law. He was fluent in it. He knew which court asked which question. He knew that the tax roll and the letter book would never compare notes. This is the nature of systemic exploitation in any era. It does not usually require illegality. It requires fragmentation. Enough competing systems that no single one ever sees the whole picture. The workers saw the whole picture. They just couldn't speak it into a record that the law would hear. Closing. The question that remains. We don't know what happened to the 17. Some may have eventually claimed freedom under the year-and-a-day rule. Some may have been recalled to their lords' estates. Some may have died in London, in a ward where they were known as free men, in a ledger where they were listed as property. The aldermen continued to serve on the city council. The merchants continued to hire. The letter books continued to record. And London continued to call itself free. There's a version of history that draws a clean line between slavery and what came after, between the ancient world's explicit chattel and the modern world's nominal freedom. That line passes through the Middle Ages and says, here, at least, is where things got better. The letterbooks of Guildhall ask you to look more carefully at that line, because the people who designed these arrangements weren't ignorant of the contradiction. They were counting on it. The only question the medieval city never quite answered, and one we might recognize in other forms today, is this. What does it mean to be free in a system that profits from not defining freedom too clearly? Leave your opinion in the comments, your like and subscription to life in medieval Britain until the next video.